Hey y'all, I'm back with another negotiable instruments video. I'm sorry this one's a little bit later than I had hoped. This is a follow-on to the previous video that was also about liability on the instrument, or related to that topic. It was focused on the underlying transaction and how the instrument relates to that underlying transaction, and also dealt with the topic of a check being offered as payment in full for an obligation. So those two topics were dealt with in the previous video under the broad heading of liability on the instrument. This one is dealing squarely with liability on the instrument, and in particular the parties that sign the instrument and what that means. And as you see here, the title is "You Sign, You Pay." It almost always. Of course, we know that in law nothing is ever 100%, but there are always exceptions. But you can certainly say, as a general rule, if a party signs the instrument, they are typically liable on that instrument. So let's get into it and see how that works. We're going to start by looking at a broad overview of liability on the instrument. As a general rule, it is what I just said, that one that signs an instrument may be liable to pay the person entitled to enforce the instrument. And we'll see that there are two key phrases in this general rule. The first being one that signs the instrument. Well, what does it mean to be someone that signs the instrument? So, well, there are a couple categories that these parties tend to fall in. One would be one who issues a negotiable instrument. So that would be the drawer of a check, the maker of a note. In the case of a certified check or a cashier's check, that's going to be the bank. And the reason I'm breaking it out separately there is because Article 3 does. It breaks out the instance of a cashier's check or a certified check as a separate thing, even though obviously you could say that, well, isn't a cashier's check a situation where the bank itself is the drawer of the check as well as the drawee? And that's true, but it is a unique sort of entity, and so it's listed separately and dealt with separately in Article 3. Then another category of parties that may sign an instrument and therefore be liable on that instrument are those who endorse it, endorsers of that instrument. And remember, we said when we talked about the topic of negotiating an instrument and talking about endorsement for the first time, we said that someone may endorse an instrument under Article 3 for a number of different reasons. One is to negotiate it, and we said that often that is how one makes it payable to the transferee that you're trying to negotiate or transfer that instrument to. It's also a way to restrict payment. You can say that it's only payable to this particular person, that it's not a bearer instrument. I'm restricting it such that it's payable specifically to the named person, individual. Or often the endorser is incurring endorsers in liability. And so those are things that come up. In essence, when you're endorsing it, you are guaranteeing payment. And that's why number 3 is there. That by incurring endorser's liability, you are communicating to the other party that you are guaranteeing that that check or that note will be paid. And so that's a reason you might do it, even though it sounds like an odd thing, just the way it's listed there. And then this third category is called an acceptor. An acceptor. So sometimes the drawee bank will accept a check. They will certify the check when they receive it, and say that we are guaranteeing that this will be paid. And in that case, they have signed the instrument, and we'll see that ordinarily the drawee bank is not someone who signs the instrument. So they are ordinarily not liable on the instrument because they don't sign. But in this case, where they decide to accept or certify that check by signature, that is one way in which they would be liable. So that's the first part of this general rule, one that signs an instrument. Well, the other part is that they are liable to who? Who are they liable to? And they are liable to the person entitled to enforce the instrument. The person entitled to enforce the instrument. Well, Section 3301 uses this phrase, defines that phrase, person entitled to enforce the instrument, sometimes abbreviated a PEIT, a person entitled to enforce the instrument. Well, what are some categories of PEITs, people entitled or persons entitled to enforce the instrument? The holder of that instrument is a person who would be entitled to enforce it. And there we just mean holder. They don't have to be a holder in due course, right? We're not saying here that they are going to be successful, that there might not be a defense that might work against them. We're not saying that here, right? All we're saying is if the person qualifies as a holder, then they fit the definition of a person entitled to enforce the instrument. And the transferee of a holder, whether that holder is a holder in due course or simply a holder because they have possession and it's payable to them, but they don't meet the other criteria, either way, remember the shelter rule gives somebody the rights of a holder or a holder in due course, even if they don't qualify independently as a holder or a holder in due course. They gain the rights of a holder or holder in due course from the transferor. And as such, that one of those rights would be to enforce the instrument. So the transferee of a holder or the transferee of a holder in due course, by virtue of the shelter rule, they will be a person entitled to enforce it, even if they don't independently qualify as a holder or a holder in due course. And then thirdly, when an instrument, if I owned an instrument or a party owned an instrument that was lost or stolen or destroyed, then often that person will retain the right to enforce that instrument, and therefore they will still be a person entitled to enforce the instrument under 3301, despite the fact that the instrument's now been lost, stolen, or destroyed. Let's focus on that third one, because with number 1 and number 2, we've looked at those things in previous lessons, but this third one, we've touched on it, but let's look at it more specifically for a second. So let's look at an example here. If we've got Bob, we've got Barb, we've got this same Honda Fit example that all of us are getting tired of, but if we're looking at it and then Bob, as a part of this purchase of the Honda Fit, executes a note. So he's the maker of that note. He issues that note to Barb, the payee. And so it's going to be pretty obviously payable to Barb. And if she has that note and then the note is lost or it's stolen or it's destroyed, well, how does that work? Can she still enforce that? Is she still somebody who's entitled to enforce that obligation? Is she a PEIT or not? And she is, and under this section, let's look, it says yes, under 3309, it says yes, but we're going to require this person, if it's a lost or stolen instrument or destroyed instrument, there's still a person entitled to enforce it here, but the party would need to prove the terms of the instrument. Here, Barb, the payee, must prove the terms of the note. And the other thing that comes up, if that instrument, remember, if it's been lost or it's stolen, or obviously if it's destroyed, it's a different situation. But if it's been lost or stolen, it may show up in the hands of a holder in due course, and therefore somebody like Bob would be liable to that holder in due course. They would be liable to them because of the fact that they're not subject to a defense that, well, I already paid this other person or whatever. So in that case, in this kind of situation where Barb has lost the instrument, she would have to prove the terms of it, prove that she has a right to collect on it, right, related to proving the terms, but then the court may require her to provide what the code calls adequate protection for Bob, such that if a holder in due course pops up, that he's not going to have double liability. He's not going to have to pay twice, both to her and to this holder in due course that may pop up. And so this adequate protection is often something like he may have to post a bond, or Barb may have to post a bond, or they may have to enter into an indemnity agreement, or there might be a letter of credit, something along those lines that would provide some protection for Bob. So just keep in mind here that this rule about needing to provide adequate protection it only comes up here where the instrument is lost, stolen, or destroyed. Don't fall into the trap of thinking, well, anytime that instrument's been transferred out from the payee, right? If Barb were to transfer it out, negotiate it to another party, if she then is coming in to try to collect, there's no requirement that the party prove anything about the instrument at that point. It only comes up when it's lost, stolen, or destroyed. And so she can still enforce this note that even though she doesn't have it, right, she no longer has it in her possession. However, she can still enforce it. She's still a person entitled to enforce it, but she's going to have to prove the terms of that and may have to provide adequate protection. Now let's look at another example here and of this same area where it's a very different result. So here, let's assume that there's a check that's given. And in this case, let's assume that it turns out that Barb is fencing cars here, that she is selling stolen vehicles. And these cars then are obviously that's an illegal thing that she's doing, and this check then is the proceeds of an illegal sale, right? It's the proceeds of the sale of stolen goods. And so let's assume that the check is confiscated by the authorities as proceeds of an illegal sale. So she never gets to pay out on it before it's confiscated. Can she say, well, I've lost it, it's stolen, it was destroyed because the authorities took it? And the answer is no, it doesn't fall under that. Why? 3309 does not apply. We don't treat it as a lost or a stolen or destroyed instrument if it's been confiscated lawfully. If it was lawfully seized by the authorities, as it was here, it's not lost, it's not stolen. So therefore, it doesn't fall under 3309. She can't collect, she is not and cannot claim to be a person entitled to enforce the instrument in that case. So again, looking at our general rule, right? We said you have to be one that signs the instrument. You may be liable to pay this particular class of people we called a person entitled to enforce the instrument, right? And so we broke it down into two questions. We need to ask, is the person who's trying to enforce the instrument, are they a Pete? Do they qualify as a person entitled to enforce the instrument? And then is the enforcement against a, quote, signer of the instrument? Do they fall into one of those categories of people we said are signers of the instrument and therefore likely liable on it? So let's look at this. Let's look at an obligation of an issuer of a note or cashier's check. So we look at this and we say, if it's a note, we've got the issuer of a note is a maker. We know that, right? That's the maker of the note. And one thing to know, and we'll come back to this later to remind you, but if the signature of the party is forged, then they did not sign it. They do not have liability, right? They're not incurring liability if it's not, in fact, their own signature. If it was forged, it does not make them liable on the instrument. So if the maker's signature was forged, if somebody signed a note in my name and it wasn't me, then that would not be effective to make me liable on that note because it was forged. So that's all I'm reminding you of there, and we'll come back to it. And you're liable for what? If you're the maker of the note, then you are liable for whatever the terms of the note are when it was issued, meaning when it was signed. But you'll note in a couple of these instances, the code says issued or completed, because sometimes people sign instruments where it's not totally filled out, that the terms of the note might not already be, there'll be blanks on it, or the check, they're signing a blank check, so it's not complete. Those kinds of things. That is why it's either when it was issued or when all the terms were completed. It's when it was nailed down, when we knew what the terms are, once we know what those are, that is what the maker is liable for, right? Once we have that nailed down, that's what they're liable for. And to whom are they liable? To the person entitled to enforce the instrument, right? To the person entitled. So we know who that is, right? We know, as we've talked about it, it's going to be a holder. It's going to be the transferee of a holder or of a holder in due course under the shelter rule, or it's going to be someone who previously possessed the instrument that was then lost or stolen or destroyed. They are going to be a person entitled to enforce. But the other thing to know is if somebody who endorsed it, who signed the instrument in this chain of transfers that often exist, if they happen to pay first, right? If the holder of the note, for instance, goes after the endorser, then the maker would be liable to the endorser if that's who ended up having to pay. We'll look at an example so that'll make sense here. So we have Bo. Bo's got a note that he has issued, right? He's the maker of the note. He's issued the note to Bob. Bob is the payee of that note. So that's what we call an issue, right? We've talked about it and so now we're saying that Bob endorses this note, right? He's endorsed the note in order to negotiate it to Barb. And so remember that often that's not the only reason you might endorse a note or a check is to negotiate it, but it's a common reason. And so in this case, we said that often you're endorsing to make it payable, right? To make it payable to the person you're transferring it to. Because you can't be a holder unless you both possess it and it's payable to you. So in this case, then Bob has negotiated the note to Barb. She's the holder. Then the note comes due. It's ready to be paid, right? And so here, Barb has this instrument, right? She has it. We're going to look and say, well, can she enforce it? She's a holder. And we said we have these two questions. Is the person seeking to enforce the instrument a Pete? Is Barb a Pete? The answer, when we looked at our definition of who qualifies under 3301, we said a holder of an instrument qualifies as a person entitled to enforce. So the answer is yes. Barb is a Pete. She's somebody who can enforce that instrument. Well, is the person she's trying to enforce it against a signer of that instrument? Well, if she's enforcing it against Bo, Bo was an issuer of the note, and he was the maker, right? He was the maker. So yes, Bo is an option that she can enforce the note against Bo. So what about Bob? What about Bob here? He's an endorser. He endorsed it for the purposes of negotiating that instrument to her. He is also liable on the instrument. He signed it. He's liable on the instrument. Okay, so that'll work as well. So the answer is she could collect from either. Let's assume she decides to enforce the note against Bob. And sometimes that's because Barb would make a presentment of the note to Bo. Bo is being difficult, refuses to pay, and she figures she'll just go to Bob and get payment because she can, and it may be easier. So let's assume that's what occurs here. And then the question is, what can Bob do? What's Bob's avenue of redress? Well, remember what we said, that the maker of a note, here Bo, is liable for what? According to the terms of the note, at the time it was issued or completed, if it was issued without all the blanks being filled in, to a Pete. Well, we can say this is that here, Bo is not an endorser, but what we can say is Bo, the maker of the note, is liable to an endorser if an endorser paid, and then he has to pay the endorser. So remember, that is what happened here. Barb ended up enforcing the note against Bob, who's an endorser, and then he paid it out. Now he can enforce the note against Bo, the maker. And yeah, maybe Bo will be difficult, but that means he just has to litigate or pursue it as best he can to try to get payment. So what about an issuer of a cashier's check, right? Because this section of our lesson, we said, was about the maker of a note, someone who issues a note, or someone who issues a cashier's check. Here with the issuer of a cashier's check, they are liable, again, on whatever the terms of the check were when the drawer/drawee bank is issued the check. If it was blank, it would be when it's completed. That's probably unlikely with a cashier's check, but hypothetically that could come up as well there. But that's what you're going to be liable to according to the terms of the check. That's what the issuer of the cashier's check, to who? The Pete or to an endorser. So it's the same. It works no differently than the note. This cashier's check. It's going to work the same way when we're talking about liability on the instrument. Here, the issuer of a cashier's check being liable. What about the drawer of a check? Just generally, any check, a drawer of a check. Well, the drawer of a check, this is important. The drawer of a check. So remember, the drawer of the checks, the person is signing the check, making the check out to pay somebody, and they sign it. But they are only liable if and only if the check is dishonored, meaning that the drawee bank does not pay it, refuses to pay it. That is the only time the drawer of the check is on the hook. So you want to make sure that that is the case, right? So if it is the case that the check has been dishonored by the drawee bank, then the drawer is liable to pay according to the terms of when it was issued or when it was completed. So they are liable on the instrument if and only if the check is actually dishonored. And who are they liable to? They're liable to whom? They're liable to a person entitled to enforce the instrument. And as always, to an endorser who's paid, then they have to pay that endorser. So, and we'll look at, so I'm not gonna, it's not that I'm avoiding an example of a check. We'll look at one, but I want to save it here for once we look at endorsers, because that adds a little more complexity to the picture here. So with an endorser, so we're saying, what about the liability of an endorser? Well, an endorser is liable for what? They're only liable, just like with the drawer of a check, except here, an endorser, this is true whether it's a check or whether it's a note, an endorser is only liable if the instrument is dishonored, meaning in the case of a check, that the drawee bank refuses to pay it. In the case of a note, that it's been presented to the maker and the maker refuses to pay it. That is when it's dishonored. It's only if it's dishonored and there's been proper notice given to the endorser that they are then liable to pay according to the terms of that note or check. So liable to whom? As always, to the Pete and then to an endorser. And I kind of clarified it here by saying it's a subsequent endorser they would be liable to. It has to be an endorser that's after them, because we're talking specifically about an endorser, and they're not liable to endorsers that are behind, precede them in the chain, and they're liable only to those endorsers that would follow them, who may end up having to pay. So under section 3.4.15, it tells us this, that an endorser is not liable if, one, she signs without recourse. So you can write in your endorsement without recourse, and that will restrict liability. It's not a cure-all, so you don't want to assume that, well, if the person writes without recourse, they can get away with absolutely everything. The answer is no, they can't, but they can write that. If they're an endorser, that will mean that they can endorse without incurring endorser liability. What that has the effect of doing is separating out the functions of an endorsement, because we said one of the functions of an endorsement is to guarantee payment, to incur endorser liability, right? To say, I will be liable on that instrument. And to separate that guarantee of payment out from the function of wanting to negotiate it, right? For the purpose of negotiating, which we said is one of the other purposes. And so you're separating those out when you write without recourse. You're saying, I am negotiating this, but what I'm not doing is guaranteeing payment of that. And so that is allowed, and the endorser is not liable if it's signed in that way. So the other thing is they must receive proper notice of dishonor under Article 3. So they've got to receive proper notice. They're not always required. You have to look at Article 3 to see when are they required and when are they not. But when they are, if they have not received proper notice of dishonor, then that would be a reason they would not be liable as well. Then, if the check is not presented within 30 days of the endorsement, okay, if the check is not presented within 30 days of endorsement. So there's a 30-day window there for how long they're liable. If it's not presented within 30 days of the endorsement, then they're not liable on the instrument after that. But keep in mind that doesn't apply to drawers. If you're the drawer of the check, it's not an endorsement. You shouldn't be looking at this, but just don't get confused about that 30-day window there. It's about endorsements, not about the actual drawer of the check. And also, remember that an endorser is only liable if the instrument has first been dishonored, just like the drawer of a check is only liable if the if the check's been dishonored. So here, if we're looking at this, and here I've got a note kind of giving this example of an endorsement. But here you've got a maker Bo again, who is issuing this note to Bob the payee. And then that note is then negotiated to Barb, and we have Bob again endorsing that note. And so there's a negotiation of the note. And then here we're going to add in another negotiation here, which is we have a negotiation from Barb to Herman. And so Barb has signed this instrument for the purposes of negotiating it here, right? And we don't have anything here about limiting liability by saying without recourse or anything like that. So this is just, these are straight up negotiations of the note. And now Herman's holding this, right? And the note comes due, meaning it's time for the maker of the note to pay up. And so Herman presents that note. This is the time, right, where this is the presentment where you're saying it's come due, please pay, maker. And if Bo refuses to pay, as I'm saying he is here, then he's dishonored the note. Dishonored the note. So at that point, the question is, can he collect from somebody else? And the answer, remember, is he can collect. He is, because he's a holder, he's a person entitled to enforcement, he can go after an endorser. He can go after an endorser, right? Because we can say, well, what is Bob here? Bob is an endorser. And the endorser is liable for what? Well, we said only if the instrument's dishonored. It has been dishonored. It was presented to Bo and Bo refused to pay it. And then what is it that Bob is liable for? He is liable to pay according to the terms of when that note was issued. And liable to whom? To a person entitled to enforce. Well, that means who is that? Well, that is, in this case, that person is Herman, who is a holder of that note, right? So the answer is he is a person entitled to enforce the instrument. So we know then that it's Bob who signed it, that Herman is a holder of that, and he's able to enforce the note against Bob in his capacity as an endorser of that instrument. So where does that leave Bob? Does he have any recourse? And one option to say is, well, can't he sue Barb because Barb is also an endorser? Isn't that somebody he could sue? Well, we can look at this and say, okay, yes, he is an endorser, and the instrument was dishonored, and he's actually already had to pay out on it according to the terms of it. But the thing you've got to look at is, well, she is an endorser, and it was dishonored, etc. But Bob, she's not liable to him, right? She's not liable to him. So, because she's not a Pete, but the other thing to recognize is she is liable to a subsequent endorser that paid. Bob is a preceding endorser that paid. People who come after her in the chain, she can be liable to them. To them, she is liable. If somebody subsequent had paid, but he is preceding, and so therefore she is not liable to him, right? So that's where it fails. So he's not going to be able to enforce there. He can go with option 2, which is to go after the maker of the note, right? Because he's the maker of the note, right? We're looking at who's he suing? Bo. For what? He's liable for the terms of the note as it issues complete. To whom? Is Bob a person entitled to enforce? No, he's not, right? You go back. He's not a holder of the instrument. He's not the transferee of the holder of the instrument. And he is not the owner of a lost, stolen, or destroyed instrument. He's not a Pete. But what is he? He's an endorser who paid, and therefore the maker has to pay him. So he would be successful, or at least he is allowed to enforce the instrument against Bo. He might have to litigate it. But what about the obligation to drawee bank? Something we said early on in this lesson is that a drawee bank typically does not sign. When we were looking at a person who signs an instrument or one who signs an instrument, we said typically a drawee bank is not one of those parties. That there is an exception, which is normally, that's why I've noted here, the answer is normally they're not liable. Normally they are not signing it because they're the drawee bank. They're the ones being ordered to do it. They have no reason to sign it. The exception is if they act as an acceptor, which is what we said at the very beginning of the lesson. We were looking at what does it mean to be one who signs the note or signs an instrument. So in this case, if the drawee bank is signing it in order to certify or to accept it, basically say, yes, we guarantee this, then that would be them signing the instrument and incurring liability when they ordinarily would have none, as is noted here. So to whom would it be? It would be to a Pete, and then again to a subsequent endorser who paid. What counts as a signature? Now, this is something we've looked at early on at the very first lesson even, and the one right after that, we were looking at what makes something negotiable. But just to review, right, because this is important because we said liability on this instrument is turning on, has the party signed the instrument? And we said that there are all these different capacities in which one may sign the instrument as an issuer or endorser, an acceptor in the case of a certified check or a cashier's check. And we said, and we know that the rule, and 3401 says it, a person is not liable unless they sign the instrument themselves or through a representative. So they have to have signed it themselves or through a representative, which is one reason why, again, a forged signature isn't going to work because they didn't sign it themselves or through a representative. But if we're going to say, okay, these are a signature is vital for liability in the instrument, well, then what does it mean? Let's get a quick review here. You can sign, just as we said, the rule under Article 3 says you can sign yourself or through a representative. You can sign by hand, I think Article 3 says manually, or by a device or a machine. You don't have to sign your name. It can be an assumed name, a trade name. It can be any name. You can use a word, a mark, a symbol if it's being executed with the intention to authenticate the writing. Then it's fine. Those are all things we said when we were saying that to be negotiable, the instrument has to be signed. And we were talking about, well, what does that mean? So here, we're adding a couple more parameters, which is that I've said this, and I don't mean to beat a dead horse, but I want to remind you that a forged signature doesn't count. It's got to be you yourself signing or your representative, not somebody forging your signature. They cannot make you liable on that instrument. Then if they're a representative, the person signing as a representative is not liable on the instrument in their own capacity, assuming it's clear that they're signing in a representative capacity and not in their own capacity. But if that's clear, then even though they were the one who signed, they did so as a representative, not as them in their own capacity. So they themselves are not liable. And what about when you have multiple parties signing an instrument? This is where you get joint and several liability in the situation of a negotiable instrument, which is if you have multiple parties signing in the same capacity, like as a maker of the note or as the drawer of the check. If you have multiple parties signing in the same capacity on it, then they are jointly and severally liable on that instrument in the capacity, that liability works for the capacity in which they signed it. They're jointly and severally liable, which means, just remember from torts, right, that they're liable for the full amount, right? They're all liable jointly and individually, and so that amount could be taken from one party, but then there would be a right of contribution, just like you talked about in torts. So there's joint and several liability. The key thing being, if they're signing as co-parties, it must be in the same capacity, and if it is, it triggers all these rules that should be familiar to you about joint and several liability. And then what about presentment and dishonor? We know that in the case of a drawer's liability, and in the case of a endorser's liability, these are important things, presentment and dishonor, right? Just to remind you, with an endorser, that they are only liable if the instrument, so the check or the note, has been dishonored. And then the drawer of a check is only liable if the check has been dishonored. The drawee bank refuses to pay. So how do we know whether dishonor has occurred or not? How do we know? Well, here's what the rule says. It says dishonor occurs if the instrument is properly presented after it becomes due. Right? If it's got to be due, like the note is due, now I'm presenting it, and the party refuses to pay, right? The check is here, I'm presenting the check, it's the date has come for everything to be paid, and I'm presenting it, and the bank refuses to pay. Then that is dishonor. So if we have dishonor and checks, right? I said we'd talk more about checks, and we will. So here we've got a drawer, an issuer of a check. Remember that when Bo is writing out a check, typically it is written on his own account, right? He's drawing it on his own bank account, and he's ordering his own bank to pay something here to Bob. He's saying to Bob, the payee. Remember, a check is a three-party instrument. The drawee, there's the drawer, Bo, who signs the check. He's ordering his bank, the drawee bank, to pay something to Bob. At this point, it is only going to have been signed by Bo, the drawer. And then often what will happen is Bob will negotiate this check, right? He will endorse it on the back and give this check to his bank, and they will be a holder of that check. Now, keep in mind here, there is a rule under Article 3 which says, in the case of if they're to your depository bank, the bank at which Bob makes his deposits, then even if he were to forget to endorse it, Article 3 says that's an exception. So if I'm making a deposit here, I have him making an endorsement. But if he were to forget to endorse it, the bank at which you are depositing your money is considered a holder regardless of whether or not he endorses it such that it's payable to them. That's an exception. But in this case, I'm just making it explicit that he's endorsed it, that they are a holder. They have possession. It's payable to them. So we can look and say they are a person entitled to enforce this instrument, right? This check. And so when it comes due, they present the check to the drawee bank. Right? There's presentment, and they're saying, pay out this check. Pay it out. And so that's what they're calling for here. Pay it out here, and they're presenting it. And if they refuse, they've dishonored that check. And at that point, that dishonoring would trigger liability for the drawer, right? It would trigger liability for the drawer. And also, the other thing we said with a note, right? We back to this example we looked at with Herman. And if the note, he presents it to the maker, Bo, and then he refuses to pay, we said it would be dishonored. That's being dishonored because he presented it. It's proper presentment. Then there's a refusal to pay. That's the dishonor. At that point, endorser liability would kick in, right? Because they first has to be dishonored. So if we're talking about, I meant to have that. That's out of order. I apologize. It should have been before this. This was with a check, and then this was with a note. So that should have been before that. I apologize. So when you think about presentment, then you want to think about it this way: that what's required for presentment is that the person entitled to enforce it, they have to exhibit the instrument. They have to give reasonable identification. In other words, identifying who they are. That, proving who they are, and that I have the instrument, so they're exhibiting the instrument, they're proving who they are. Then if they are making a presentment on somebody else's behalf, then they have to give evidence of their authority to do that, right? So that the person being asked to pay knows that this is genuine, that they're not being duped. And if then with presentment, then whoever has presented it, the holder, if it's been fully paid, the instrument should be surrendered to the party, to the maker of the note, for instance. If it's only been partially paid, then that amount should be noted and on the instrument and signed. So the other thing to know here about presentment and notice of dishonor, which we said is important when we're talking about an endorser or a drawer, that they are sometimes excused. And I will just point you to section 3504 to see the instances in which it is excused. They're spelled out there in section 3504. So that's it. I hope that's helpful. I will be back shortly with more. If it was helpful, as always, like, subscribe. Thanks a bunch, and I will see you soon. Bye.